Melbourne in the late 1980s and early 1990s was a city of expanding suburbs, of families living in houses with back fences and quiet streets where children walked to school and played in gardens that felt, to those who lived there, like extensions of the home rather than places of danger. The northern and eastern suburbs in particular carried that particular quality of Australian suburban life, where neighbours knew one another by sight and where the rhythms of school terms and weekend sport organised the week. It was into this ordinary landscape that a series of crimes entered, crimes so methodical in their planning and so consistent in their pattern that Victoria Police would eventually conclude they were the work of a single offender, a man the newspapers would call Mr. Cruel, a name that captured public fear without capturing an identity. The official record does not begin with that name. It begins with individual cases, each reported separately, each investigated in the context of its own geography and its own family. Over time, investigators linked these cases through modus operandi, through victim statements, through the careful comparison of methods that cold case work depends upon when a perpetrator takes pains to remain unknown. Victoria Police believe one offender was responsible for the linked attacks. That belief is an official finding built from pattern analysis. It has not produced a conviction. The victims were girls, roughly between 10 and 14 years of age. They were taken from their homes, often at night, often after what investigators would describe as a period of surveillance. The offender demonstrated preparation. He knew where to enter. He knew when parents would be absent or asleep. In several cases he cut power to the house, an act that suggested familiarity with electrical systems and that would later become one of the threads investigators followed when they considered whether the offender might have worked in or near the electrical industry. He wore gloves. He covered his face. He cleaned scenes with a thoroughness that police have described as exceptional, as though he understood forensic procedure or had reason to fear leaving traces. The first case now formally linked in the official narrative occurred in August of 1987 in Lower Plenty, a suburb northeast of the city centre. Two sisters were abducted from their home while their parents were at work. They were held for a period and then released. Their statements, taken with care by investigators, described an offender who spoke with authority, who controlled the environment, who bathed them and who eventually returned them to the world they had been taken from. The detail of release after a stated interval, described by one victim as precise enough to be counted in hours, became part of the pattern file. This was not impulsive offending in the official assessment. It was planned. In December of 1988, 10-year-old Sharon Wills was taken from her home in East Ringwood. She was held for approximately 14 hours and released alive. Her account aligned with the Lower Plenty case in ways that satisfied investigators that the same person was responsible. Again there was preparation. Again there was concealment of identity. Again the victim survived to describe what she could, which was more than the offender may have intended but less than investigators needed to name him. In July of 1990, 13-year-old Nicola Linus was abducted from her home in Canterbury during a family visit. Her sister was present in the house. The offender tied the sister and took Nicola. Nicola was held for nearly 2 days before being released. She provided a detailed description of the offender's methods, of the way he maintained control, of the environment in which she was kept. Victoria Police used her statement to refine their understanding of the pattern. They also noted that in cases where victims were released, the offender sometimes took clothing from their homes and dressed them before returning them, a detail that suggested a level of planning and psychological control that investigators documented carefully without sensationalizing it. The case that would define the public understanding of Mr. Cruel came in April of 1991. 13-year-old Carmine Chan was abducted from her family's home in Templestowe while her parents were at work at their restaurant. She was taken at knife point. Her abduction occurred in circumstances that matched the earlier cases closely enough that police linked it to the same offender within 24 hours. Graffiti left on a family vehicle was assessed, in the official account, as a deliberate attempt to mislead investigators about motive. Carmine Chan did not return. Her body was found 10 months later, in Thomastown, in a location that investigators have examined for its proximity to electrical infrastructure and to other features of the offender's known movements. Following Carmine's abduction, Victoria Police formed Operation Spectrum, a task force that would run for 29 months and involve 40 full-time investigators. The scale of the inquiry was substantial by any measure. More than 10,000 public tip-offs were received. Approximately 30,000 homes were searched. 27,000 people were interviewed, a figure that included doctors, teachers, journalists, and police officers themselves. 73 arrests were made in the course of the investigation. None led to the identification of Mr. Cruel. A reward that began at $100,000 increased to $300,000 during the search for Carmine, and would later, in 2016, reach $1 million for information leading to conviction in her murder. The investigation produced a profile rather than a name. Police have described the offender as intelligent, cautious, and methodical. He surveilled victims and their families before acting. He took extreme measures to avoid leaving forensic evidence. Detectives believe he may have recorded his crimes, a theory based on victim statements and on behavioral analysis rather than on recovered material in the official file. He is believed to have continued collecting child exploitation material if he remained alive, an assessment offered by investigators as part of their long-running appeal for information from anyone who might know him. The electrical connection emerged as an investigative thread rather than as a proven fact. Victims in some cases were abducted near or found near electrical substations. Analysts mapping the cases have suggested the offender may have worked in the electrical industry, posed as a substation employee, or lived near such infrastructure. This remains in the realm of investigative hypothesis. It has not been confirmed by a conviction. Similarly, profiling work conducted in later years, including analysis by American behavioral specialists, has proposed that the offender may have begun as a burglar who escalated in severity over time. That proposal is theory. It helps investigators think about motive and progression. It does not appear in a courtroom as established fact. Victoria Police have considered multiple possibilities for why the offending stopped after 1991. The offender may have died. He may have left the country. He may have been imprisoned for unrelated crimes. He may have been interviewed during Operation Spectrum without investigators recognizing him at the time. Assistant Commissioner Stephen Fontana stated publicly in 2016 that police had not ruled out the possibility that they had spoken to Mr. Cruel during the investigation. 32 persons of interest could not be eliminated as of that appeal. The case remains open. The loss of some early exhibits complicated the historical record. The head of the Spectrum Task Force acknowledged that items including tape and rope used in earlier linked cases had been lost or never fully examined by forensics when first collected. This is a recurring feature of long-running investigations. Evidence handled under one era's standards may not survive for re-examination under another's. The official file carries both the weight of a massive inquiry and the gaps that time and procedure create. Before Operation Spectrum, an earlier unit called Operation Challenge had investigated the surviving cases. The escalation to a dedicated task force after Carmine's abduction reflected police assessment that the offender had crossed a line from abduction and release to killing. Detectives noted that Carmine was described by those who knew her as spirited and assertive, qualities that investigators have suggested may have led the offender to conclude she could identify him if released. That assessment is inference from behavior, not testimony from the offender. It helps explain why the final case in the series ended differently from the others. It remains theory grounded in victimology rather than confession. Public appeals over the years have emphasized that the offender likely lived or worked in Melbourne's northern or eastern suburbs during the period of offending. Age progression work on composite images has been released in the hope that recognition might come from someone who knew him in the late 80s or early 90s rather than from forensic breakthrough alone. Victoria Police have offered indemnity from prosecution through the Director of Public Prosecutions for anyone who provides information leading to identification. The logic is straightforward. Someone close to the offender may have suspected and remained silent. Time may have altered what silence means to that person now. For the victims who survived, life continued under the shadow of what had happened. For Carmine Chan's family, the shadow did not lift with a release. Her mother, in a gesture that received wide attention, stood at her front gate at midnight and rang bells, calling her daughter's name in the hope of return. The community around Templestowe and the wider Melbourne public followed the case with an intensity that reflected the particular fear of a predator who entered homes. That fear changed how some families thought about locks and lights, and the trust extended to ordinary suburban evenings. Whether it changed enough to prevent further harm by this offender is unknown, because the offender was never identified. It is important to separate what Victoria Police have established from what remains speculative. They have established that multiple abductions between 1987 and 1991 share a modus operandi consistent with one offender. They have established that Carmine Chan's abduction and death are linked to that series in the official investigation. They have established that a major task force investigated thousands of leads without producing a charge. They have not established who Mr. Cruel is. Theories about tradesmen, electrical workers, former police experience, interstate relocation, and death or incarceration all circulate in public discussion. None has closed the file. The name Mr. Cruel came from a newspaper headline, not from the offender himself. It fixed a label on an absence. Decades later, Melbourne's northern and eastern suburbs are changed in many ways, but the cases remain in the cultural memory of Victoria, taught as cautionary history and carried as unfinished business by the homicide squad. Rewards still stand. Appeals still run. The official position is that someone in the community likely knows the truth, likely knew it then and may know it now. For listeners resting in the quiet of a late hour, the case may settle as a study in pattern recognition without resolution. An offender who planned each entry, who studied each family, who cleaned each scene, who spoke to victims with a calm that survivors remembered, and who nevertheless left no name in the record. An investigation that interviewed 27,000 people and searched 30,000 homes and still could not convert pattern into identity. The official findings, stated plainly, are these. Between 1987 and 1991, a single unidentified offender abducted multiple girls from Melbourne homes in linked cases investigated under Operation Spectrum. 3 victims were released alive and provided consistent accounts. Carmine Chan was abducted in 1991 and murdered. Her body was found in 1992. Victoria Police believe the offender may still have been alive as of recent appeals, or may have died or left Australia. No one has been charged. The investigation remains open. Theories continue. Electrical industry connection. Burglary escalation. Prior law enforcement knowledge inferred from scene cleaning. Offender deceased or imprisoned elsewhere. Each theory offers a shape to the silence. None has produced a courtroom verdict. Melbourne tonight is as it was in ways that matter. Suburban streets. Houses with back fences. Families asleep behind doors that most nights remain secure. The file holds its questions. If a person can enter a home with such preparation, leave such consistency across years and victims, and still vanish from the record after an inquiry of 30,000 searches, what does it mean to trust that the most careful investigation can always find the one person who chose to remain unseen? Bowraville is a small town on the mid-north coast of New South Wales, a place where community life moves at the pace of familiar faces and known routes, where the Nambucca Valley holds both the beauty of coastal hinterland and the closeness that small settlements require of their residents. In the early 1990s, Bowraville was home to families who had lived in the area for generations, including Aboriginal families whose connection to country and community ran deeper than any single headline could contain. It was into this landscape, over a period of 5 months, that 3 children disappeared. Their names are Evelyn Greenup, Clinton Speedy Duru, and Colleen Walker. Their families have carried grief and advocacy for more than 3 decades. Their case remains one of the most painful unresolved chapters in Australian criminal justice, not only because of what happened to the children, but because of what followed in courts and in law. Colleen Walker was 16 years old when she was last seen in September of 1990. She disappeared from the Bowraville area in circumstances that would later be examined in coronial proceedings and in legal argument stretching across decades. Her body has never been found. A coroner has ruled that she is deceased, that she died at or near Bowraville, and that she was likely murdered. No one has been charged with her death. That absence in the formal record sits alongside the losses of the other 2 children as a wound the community has not been able to close. In October of 1990, 4-year-old Evelyn Greenup disappeared after a gathering at her grandmother's house. She had been put to bed and was not there when the household woke. Her mother reported feeling unusually unwell that evening, sleeping deeply in a way that later testimony would revisit. Evelyn's grandmother recalled hearing a brief cry in the night. Attendees at the gathering would later describe who was present. Evelyn's remains were found in bushland near Congarini Road in April of 1991. Pathology could not conclusively determine cause of death, though a skull injury was noted as consistent with forceful penetration by a sharp instrument. Evelyn was a child. Her family has spoken publicly with dignity and persistence about their loss and about their pursuit of justice. Clinton Speedy Duru was 16 years old when he went missing in January of 1991. He had been at a gathering at a place known locally as the Mission. Witnesses noted he appeared heavily affected by alcohol, which those who knew him considered unusual. He was last seen in connection with a caravan associated with a local man who would become the central figure in police investigations and in 2 criminal trials. Clinton's body was found in bushland near Bowraville on the 1st of February, 1991. He had died by violence. His family, like Evelyn's and Colleen's, has never accepted that the legal process delivered the justice they sought. From the beginning, police linked the 3 disappearances. Investigators identified a local man as their primary suspect. He was charged with the murders of Clinton and Evelyn. He was not charged with Colleen Walker's death, though the families and police have treated the 3 losses as connected in the narrative of the investigation. What the courts would decide is a separate matter from what investigators believed. That distinction matters in any account that respects both official findings and the limits of what trials proved. The early police response has been criticized in official inquiry as well as in family advocacy. Colleen Walker's disappearance did not immediately trigger the same urgency as later cases would. Evelyn Greenup's age and the circumstances of her vanishing from a family home during a gathering raised alarms that still did not produce swift resolution. Clinton Speedy Durua's death confirmed that violence had visited the town, yet the legal process that followed would take years to unfold and decades more to exhaust. Bowraville is not a place that forgot. It is a place that learned how slowly wheels turn when evidence, admissibility, and acquittal intersect. The caravan in which Clinton spent his last hours became a focal point in testimony. His girlfriend woke to find him gone and some of her clothing removed. Witnesses described movements through the early morning. The suspect told police he had seen Clinton leave at 5 in the morning and not return. These details formed part of the prosecution narrative in both trials. Jurors heard them and twice returned not guilty verdicts. The families have never interpreted those verdicts as exoneration in the moral sense. Legally, however, they are the boundary beyond which the state could not proceed under the rules that governed each trial and the retrial application. The first trial, in 1994, concerned Clinton Speedy Durua's murder. The prosecution had sought to try the Clinton and Evelyn matters together, relying on evidence that the deaths shared features pointing to the same offender. The trial judge ruled that this evidence was not admissible in the form presented, and ordered separate trials. The jury acquitted the accused of Clinton's murder. Following that acquittal, the Crown withdrew the indictment relating to Evelyn. For a time, there was no second trial. Years passed. The families campaigned. Community advocacy drew attention to the initial police response, which had treated early disappearances in part as missing persons matters before the pattern became clear. An inquiry into the family response to the murders, conducted in 2014, documented failures and delays that the families had long described. The legal landscape also changed. In 2016, New South Wales amended its double jeopardy laws to allow retrial for serious offences when fresh and compelling evidence emerged. That reform was driven in significant part by the Bowraville family's advocacy. It offered a pathway that had not existed when the first acquittal was entered. A second trial for Evelyn Greenup's murder took place in 2016. The jury acquitted the accused again. 2 acquittals now stood in the formal record. The families continued to seek a further trial that might present the 3 deaths together under evidence rules that had evolved since 1994. The New South Wales Director of Public Prosecutions and later the Attorney General pursued applications under the new double jeopardy provisions. The question before the courts was not simply whether investigators still believed the same person was responsible. It was whether the law permitted another trial and whether the evidence qualified as fresh and compelling under the statute. In 2018, the New South Wales Court of Criminal Appeal rejected an application for retrial. The court held, in a lengthy unanimous judgment, that evidence relating to Colleen Walker was available at the time of Evelyn's trial, even if it had been inadmissible then, and therefore could not be treated as fresh. Because the Attorney General's case depended on trying the matters together, the court did not proceed to consider whether fresh evidence existed for Clinton's murder alone. The application failed. The High Court of Australia declined to hear a further appeal in 2019. Under current law, further retrial applications are barred. The acquittals stand as the definitive legal outcome for the charged offences. This is the official position stated plainly. A man was tried twice and acquitted twice. The investigation remains technically open. Police have not secured a conviction for any of the 3 deaths. Colleen Walker's murder has never been charged. The family's belief that one person was responsible for all 3 losses aligns with the police view in the investigative file, but belief and proof occupy different rooms in the law, and the courtroom has twice returned not guilty verdicts on the charges that were brought. Theories in public discussion often treat the acquittals as failures of evidence rather than as proof of innocence. That framing is understandable given the family's position and the linked investigative narrative. It is not, however, what the verdicts formally establish. An acquittal means the prosecution did not prove guilt beyond reasonable doubt on the charges tried. It does not answer every question the community asks. It does not locate Colleen Walker. It does not restore Evelyn or Clinton to their families. It leaves Bowraville with a legal finality that feels, to those most affected, incomplete. The case also illustrates how procedural rules shape outcomes. The decision to separate trials in 1994 affected what juries heard. Changes to tendency and coincidence evidence law in 1995 meant that evidence deemed inadmissible at the first trial might have been admissible later, but the Court of Criminal Appeal did not treat that shift as producing fresh evidence for the purposes of double jeopardy reform. The family's victory in changing the law did not, in the end, produce the retrial they sought. That arc is part of the official history now, taught in law journals and cited in debates about how Australian courts balance the rights of the accused against the community interest in resolving serious crime. For the Aboriginal families at the centre of this story, the case carries layers that no single narration should flatten. Evelyn, Clinton, and Colleen were children of a community that had already experienced disproportionate harm from institutional failures across Australian history. Their disappearances occurred in a town where relationships were entangled and where trust was damaged by the pace and character of early investigation. The families have spoken with strength and clarity over decades, refusing to let the children be remembered only as file numbers. They have asked for justice in courts and in public forums. They have accepted legal defeats and continue to advocate. That persistence is part of the record as much as any court judgment. It is important to distinguish what has been established from what remains unresolved in different senses. Investigators established links between the cases in their operational assessment. Courts established that 2 murder charges did not result in conviction. A coroner established that Colleen Walker is deceased and likely murdered. No court has established who killed any of the 3 children. The named suspect in media and legal reporting cannot be identified here in a way that overrides the legal protections attached to acquittal, but the public record is clear that one individual was the focus of both trials and of the failed retrial application. Bowraville today is still a small town. The bushland where remains were found holds silence that searchers and families know differently. The legal reforms prompted by this case remain in statute, serving cases beyond Bowraville while leaving Bowraville itself without the verdict the families pursued. Police continue to treat the matter as open in the technical sense. The community continues to live with memory. For listeners resting in the quiet of a late hour, the case may settle as a study in how law processes tragedy. 3 children lost in 5 months. 1 suspect charged twice. 2 acquittals affirmed against retrial. A 3rd child never found. Families who transformed personal loss into legislative change and still did not receive the courtroom outcome they sought. An investigation that never converted shared belief into final conviction. The official findings, stated plainly, are these. Evelyn Greenup, Clinton Speedy Duroux, and Colleen Walker disappeared from Bowraville between September 1990 and January 1991. Evelyn and Clinton's bodies were recovered. Colleen Walker has not been found but is presumed murdered. A local man was acquitted of Evelyn's and Clinton's murders at trials in 1994 and 26. Applications for retrial under amended double jeopardy law were rejected in 2018. No one has been convicted. The investigation remains open. Theories continue, particularly among families and supporters, that one offender was responsible for all 3 deaths and that the legal system failed to deliver justice. That view is not the same as a finding of guilt. It coexists with acquittals that the law treats as final. Each layer offers a shape to the silence. None has brought the children back or answered every question Colleen Walker's absence still asks. The Nambucca Valley tonight holds its ordinary darkness. Bowraville sleeps. The families hold what courts could not give them. If a community can change the law itself in pursuit of justice and still be told that the past must remain past, what does a verdict mean when the living remember what the record cannot finally prove? Thornbury sits in Melbourne's inner north, a suburb of shopfronts and residential streets where the 20th century's commercial life persisted in second-hand bookshops and corner stores long before the area became fashionable. High Street carries traffic and footfall in a rhythm that changes with the hour but rarely stops entirely. On a winter Tuesday in 1980, that ordinary commerce enclosed a tragedy that would remain unresolved for more than 4 decades, a stabbing in the back room of a bookshop that doubled as a home, within earshot of 2 young sons who were not harmed but who would spend the rest of their lives asking who killed their mother. Maria James was 38 years old. She was a single mother running a second-hand bookshop at number 736 High Street. The shop was also where she lived, in adjoining rooms that made the boundary between work and domestic life a door rather than a commute. On the 17th of June, 1980, she was murdered in her bedroom. She had been stabbed many times in an attack that investigators and her family have described as frenzied. Her older son, Mark, was at school. Her younger son, Adam, was in the flat. Adam was not injured. When Mark returned and could not enter because the door was locked, he went to a neighbor for help. The neighbor forced entry. Maria James was found dead. The initial police investigation was extensive in scope. Detectives interviewed numerous persons of interest. Suspects included individuals connected to Maria's personal life and to the community around the shop. A man was seen running from the direction of the premises around the time of the killing. Police produced sketches. That man has never been identified in the official record. The front door was unlocked when Mark arrived, which investigators interpreted as suggesting that someone left the scene before the boy returned. These are established facts from the investigation. They do not include a named killer. The case entered a long second life decades later, driven in part by journalistic investigation and in part by the persistence of Maria's sons. In 2017, the ABC podcast Trace examined the murder and uncovered material that led to a fresh coronial inquest and to renewed police attention. Among the claims explored were connections to the Catholic Church, allegations of historical abuse, and suggestions of institutional interference with the original investigation. Adam James had told his mother, in the days before her death, that he had been sexually abused by a priest. That disclosure became part of the re-investigation's context. Victoria Police examined cover-up claims. The official outcome of that examination, stated in subsequent years, is that no charges arose from the re-investigation into institutional interference. The claim was investigated. It did not produce a prosecution. That distinction matters when separating media narrative from police findings. Several persons of interest have been publicly discussed over the years. Father Thomas O'Keefe, a Catholic priest who had heard Adam's confession, was investigated in the early years. Father Anthony Bongiorno, another priest connected to the parish context, became a focus of later inquiry. Peter Keogh, who was convicted in unrelated circumstances for the 1987 killing of his former partner Vicky Cleary, was also examined as a person of interest in Maria James's death. Bongiorno and Keogh are deceased. O'Keefe is deceased. None was charged in Maria James's murder. Victoria Police have stated that persons previously identified as suspects remain of interest where the investigation continues, but that insufficient evidence exists to charge anyone. The re-investigation also exposed failures in exhibit management that damaged the forensic possibilities of the case. Clothing and bedding from the murder scene were mislaid in the early 1980s. A pillow from an unrelated case entered the exhibit chain and led, at one stage, to DNA testing that wrongly excluded certain suspects. When the error was discovered, years of investigative progress had been lost. A coronial inquest in 2021 heard that critical items, including Maria's blood-stained quilt, were missing for decades before some were relocated. DNA testing on rediscovered material, including hairs on the quilt, yielded inconclusive results as of the inquest findings. Deputy State Coroner Caitlin English delivered an open finding, the same category of finding returned in 1982. Maria James was killed by a person or persons unknown. The coroner criticized Victoria Police exhibit handling and directed a thorough search of holdings. That search has continued. The Trace podcast raised specific allegations about priests and about an electrician seen near a presbytery around the time of the murder. It questioned alibis and pointed to errors that had excluded suspects. Victoria Police did not dismiss the re-investigation. They reopened lines of inquiry. They offered increasing rewards, reaching $1 million in 2024 on the 44th anniversary of Maria's death. Detective Senior Constable Lee Prados, leading the cold case, has stated publicly that people alive today may hold critical information, particularly anyone who was in or near 736 High Street around midday on the 17th of June, 1980. The appeal continues. The conviction does not. The bookshop itself was a community fixture. Regular customers knew Maria by name. The second-hand trade brought browsers who might linger for an hour among shelves. High Street in Thornbury connected to a parish world where priests were familiar figures and where confession and counsel were part of ordinary Catholic life for families like the Jameses. That social geometry does not prove any particular person entered the bedroom with a knife. It explains why church connections became lines of inquiry when Adam's disclosure preceded the murder by days. Investigators had to ask whether those days were linked or coincidental. The reinvestigation leaned toward linkage as a working hypothesis. The courtroom standard for conviction remained unmet. Mitochondrial DNA testing on recovered hairs offered a narrow path forward at the 2021 inquest. Experts testified that familial samples from relatives of deceased persons of interest could be compared with mixed profiles from the quilt. Results described as inconclusive closed no door entirely but opened none wide enough for charge. Detective Inspector Dean Thomas has appealed for the smallest detail, a car seen, a voice heard, a person noticed near the shop at an odd hour. Cold cases of this age depend on memory surfacing when reward and indemnity alter the calculus of silence. It is necessary to hold two truths without collapsing them into one. The first is that Maria James was murdered in her home while her children were nearby, and that this crime deserves resolution. The second is that theories about church cover-up, about particular priests, and about institutional protection, while examined by investigators and coronial process, have not resulted in charges or in a finding naming a killer. Theories about jealous partners, about the unidentified running man, about Keogh's potential involvement, remain in the public discussion precisely because the case is unsolved. The official file records investigation, not proof, for each line of inquiry. Maria's sons have lived publicly with their loss. Mark James pursued answers through courts and media with a persistence that changed how the case is remembered in Victoria. Adam James carried the additional weight of disclosures made to his mother days before her death, disclosures that became part of a wider reckoning with clerical abuse in Australia but that did not, in themselves, identify Maria's killer in the eyes of the law. Their dignity in seeking justice is part of the story. It should not be confused with the legal outcome, which remains absence of conviction. Melbourne in June is cold. Thornbury's High Street in 1980 was a place of browsers and regulars who knew the bookshop owner by name. The winter light that entered the shop on the 17th of June did not return in the same way for the family who lived behind the shelves. The bookshop eventually passed out of the family's hands. The file did not close. For cold case work, the James murder illustrates how investigative failure compounds over time. Evidence lost in the 1980s cannot be recollected in the 2020s. Witnesses who were adults in 1980 are fewer now. DNA technology can re-examine what survives, but what survives is incomplete. Each coronial inquest adds detail to the record of what went wrong in the handling of the case without necessarily adding the name of who entered the bedroom with a knife. The Homicide Squad has stated repeatedly that the case remains active, that any detail may matter, that indemnity from prosecution may be considered for those who provide information leading to conviction. These are the tools available when history has already taken its toll on evidence. The 1980 investigation itself was wide-ranging in its first phase. Detectives doorknocked High Street. They spoke to Maria's former partner and to men in her social circle. They followed the running man sighting as far as sketches and appeals could carry it. The case appeared on television and in newspapers within days. Thornbury residents were asked whether they had seen anything unusual at a bookshop they may have visited weekly without thinking of it as a crime scene. That ordinary familiarity is what cold case appeals still invoke. Someone may have seen the running man and not known what they saw until decades later. The 2017 to 2018 reinvestigation examined whether institutional relationships protected a killer. Victoria Police stated they pursued those claims seriously. The absence of charges from that phase is an official outcome that must sit alongside the family's belief that the truth was knowable and perhaps known by someone who did not speak. Both can be true in different registers. Investigation can exhaust a line without confirming it. Grief can outlast every report. Mark and Adam James have said publicly that they want resolution, not endless theory. Their position does not alter the legal standard. It humanizes the file. The running man in the sketch remains a figure of official interest without official identity. The unlocked door remains a fact without a confirmed explanation. The son's presence nearby remains a mercy that does not answer the central question. Winter mornings on High Street continue. The shop at 736 is not the same shop, but the coordinate persists in maps and memory. For listeners resting in the quiet of a late hour, the case may settle as a study in reinvestigation without resolution. A murder in a bookshop. Decades of inquiry. Podcast revelations. Coronial criticism. DNA that does not yet speak clearly. Priests and partners and strangers considered and not charged. $1 million reward where a $50,000 reward once stood. A family that never stopped asking. The official findings, stated plainly, are these. Maria James was murdered on 17 June 1980 in her residence adjoining her Thornbury bookshop. She was stabbed repeatedly. Her sons were nearby and unharmed. An unidentified man was seen running from the area. Multiple persons of interest have been investigated across 4 decades, including Catholic priests and Peter Keogh. Cover-up claims were examined in reinvestigation. No one has been charged. Coronial inquests in 1982 and 2021 returned open findings. Victoria Police continue to investigate and offer reward. Theories continue. Church concealment. Particular priests as killers. Keogh as offender. The running man as key or as unrelated witness. Partner or acquaintance crime. Each theory responds to a gap the official record has not filled. None has produced a verdict. Thornbury tonight is as it was in ways that matter. Shopfronts darkened. Winter air off the street. A family asleep somewhere with a loss that began in a back room behind books. If a mother can be killed in the middle of the day with her child in the next room, and if 40 years of looking can still not name the person who walked out the unlocked door, what does it mean to believe that time alone will always bring the truth to those who wait? Wanda Beach lies south of Sydney near Cronulla, a stretch of coast where sand dunes rise behind the shoreline and where the Pacific moves in a rhythm that summer visitors have trusted for generations. On a January day in 1965, that ordinary beach became the scene of one of New South Wales' longest-running unsolved double homicides, the killing of 2 15-year-old girls who had come from West Ryde with younger siblings for a day by the sea. Their names were Christine Chirac and Marianne Schmidt. They were neighbors and close friends. They were responsible girls, entrusted with the care of Marianne's 4 younger brothers and sisters while their mother was in hospital. They did not return from a walk through the sandhills. Their bodies were found the following morning. The date was the 11th of January, 1965. Marianne Schmidt and Christine Chirac had planned a beach outing that had been postponed once by rain. On the Sunday, they set out from West Ryde with Marianne's siblings, Peter, Norbert, Trixie, and Wolfgang, and with Christine, who lived next door. They traveled to Cronulla by train. The younger children were on the beach while the 2 older girls went walking through the dunes in the early afternoon. When the siblings returned without Marianne and Christine, alarm grew through the evening. Searchers and police were involved. On the 12th of January, the girls' partially buried bodies were discovered in the sand. The pathology and crime scene examination established that both girls had suffered severe violence. They had been sexually assaulted and stabbed. Christine Chirac had suffered a blow to the head and multiple stab wounds. Marianne Schmidt had been stabbed repeatedly, including wounds that penetrated deeply. Drag marks and blood spatter in the sand led investigators to reconstruct a sequence in which Marianne was attacked first and Christine attempted to escape. The killer placed the bodies with a particular orientation that detectives documented. These are official findings from the scene. They describe what was done. They do not name who did it. The investigation that followed was, at the time, the largest in Australian history. By April of 1966, police had interviewed approximately 7,000 people. The case received sustained media attention across the country. The combination of youth, friendship, a summer beach setting, and extreme violence fixed Wanda in public memory alongside other losses of the era that seemed to mark a changing sense of safety in Australian life. Detectives pursued numerous suspects. A German migrant was investigated in Australia and abroad. Local men came under scrutiny. Witnesses reported seeing a masked man on the beach that day. Wolfgang Schmidt, Marianne's younger brother, described encountering a tanned young man on the sand, a surfer type, near his sister and Christine. That description entered the file and would be revisited decades later when new persons of interest were proposed. Despite the scale of the inquiry, no conviction followed. The case was periodically reopened as forensic methods advanced. In 2006, a review under the Cold Case Justice Project re-examined exhibits. Detectives recovered samples including a bloodstain on Christine's shorts but determined that degradation prevented useful testing. A semen sample listed in records for Marianne's swimming costume could not be located after extensive searches. The loss of that sample has been described by later investigators as catastrophic for the prospects of modern DNA comparison. This is an official acknowledgement of evidentiary harm, not a theory. Material that might have identified an offender in a later era was not available when later era arrived. In recent years, private investigators and journalists have named Christopher Wilder as a suspect in public forums. Wilder was an Australian-born man who later committed multiple murders in the United States and died in 1984 during a pursuit by law enforcement. Profiling work and photographic regression have been presented as aligning Wilder's appearance at 19 with Wolfgang Schmidt's description of the man on the beach. Wilder was known to surf at Cronulla. He lived in the broader Sydney region at the time. Retired Detective Inspector Ian Watterson, who reviewed the case, has stated publicly that Wilder stands out among suspects. This attention is significant in media and in investigative discussion. It is not the same as a charge or a court finding. New South Wales police have continued to appeal for information into the murders without announcing a solved status tied to Wilder or any other named individual. The case remains an open cold case in the official record. Other theories propose a local offender, someone who knew the dunes or who encountered the girls by opportunity rather than travel. The German migrant investigated decades ago belongs to the historical suspect file without conviction. The masked man seen on the beach remains unidentified in a formal sense. Each theory attempts to explain how two girls could be separated from siblings on a crowded summer coast and killed without immediate resolution. None has closed the file. The families have lived with loss across 60 years. Hans Schmidt, who was a child in the house when Marianne left for the beach, has spoken publicly about the Sandhills as a place of permanent memory. Christine Chirac's family endured not only her murder but further tragedy in its wake. Christine's father died of a heart attack a month after her funeral, a loss the family connected to grief. The Schmidt children who were on the beach that day carried a weight no child should carry, the return home without their older sister, the slow recognition that a walk through dunes had become permanent absence. Cold case anniversaries bring renewed appeals and renewed grief. The girls remain 15 in the public record, neighbors and friends on a January outing. The day before the murders, Marianne and Christine had visited Cronulla without the younger Schmidt children. Diary entries read later indicated the girls had kissed boys on the beach during that earlier visit, a detail that entered tabloid narrative but does not explain the violence that followed. On the 11th, the weather was poor enough that a sensible outing might have been postponed again. The girls went anyway, responsible enough to bring 4 siblings and young enough to want an hour among the dunes with a friend. That ordinariness is part of what fixed the case in national memory. There was no obvious reason in their conduct for what met them in the sand. Detectives in 1965 worked without DNA as later investigators would understand it. They relied on witness canvassing, on physical comparison of wounds to possible weapons, on the laborious elimination of persons who could be placed elsewhere. A German migrant investigated here and overseas represented the international reach the case attracted when local inquiry stalled. He was not convicted. Neither were others who passed through the file. Each decade that passed added method but subtracted witnesses. Ian Watterson's review in 2006 represented hope that science could speak where memory faded. Degraded samples and missing exhibits answered that hope with silence. For historical true crime, Wanda illustrates both the capacity and the limits of a major manhunt in the 1960s. Thousands interviewed. National attention. Suspects pursued across borders. And still no trial that ended in conviction. Forensic science of the era could document wounds and collect samples that later eras might have tested more fruitfully, but preservation and chain of custody across decades are not guaranteed. When a semen sample listed in 1965 cannot be found in 21st century storerooms, the investigation suffers a wound that no amount of publicity can stitch closed without new material or new witnesses. Christopher Wilder's later crimes in the United States established him as a serial offender of exceptional cruelty, a man who used charm and photography to approach victims before killing across multiple states. His death during apprehension in 1984 closed his American spree but left Australian files open where his name had not been tested in court. The suggestion that he killed at Wanda before emigrating is built from geography, timing, physical description, and pattern analysis. It is compelling to those who have studied the file closely. It is not a conviction. NSW police maintain the case as unsolved rather than closed by attribution. The sandhills behind Wanda Beach are not empty in the cultural sense. They appear in anniversary journalism, in family testimony, in the recollections of a brother who was 8 when his sister walked away and never came back. Marianne Schmidt and Christine Chirac were buried and mourned. Their friendship is remembered as the kind that neighbors' children form when they share a fence and a school and a summer plan. The crime did not take that memory from those who loved them. It added a second memory that does not fade with season. NSW Unsolved Homicide continues to list the matter among open investigations, asking anyone with information, however old, to contact Crime Stoppers. The appeal is quiet compared to 1965 headlines, but it has not ended. Wolfgang Schmidt's description of a tanned young man with zinc on his nose and a blue towel remains in the file as witness testimony, not as identification. Descriptions remembered by children on a beach day can guide review. They cannot, alone, convict across 60 years without corroborating evidence the modern file lacks. The beach itself has changed in some ways and not in others. Cronulla remains a destination. The dunes still rise behind Wanda. Summer days still bring families with children and towels and the assumption that the sea is a benign backdrop. The case sits in New South Wales police history as the oldest unsolved homicide in the state by some reckonings, a designation that reflects time rather than priority alone. Detectives continue to ask anyone with information to come forward. The appeal is standard for open homicides. It is also sincere. Cases this old depend on memory that survives, on guilt that moves someone to speak, on detail held for decades and finally released. It is important to distinguish official status from investigative opinion offered in retirement or in media. The murders are unsolved. No one has been convicted. Christopher Wilder is a strong suspect in the assessment of some who have reviewed the file. That assessment has not been converted into the official closure of a charge and verdict. Local offender theories remain unproven. The masked witness remains unnamed. The lost DNA remains lost. For listeners resting in the quiet of a late hour, the case may settle as a study in summer light turned permanent shadow. Two girls entrusted with siblings. A walk into dunes. A night of searching. Morning discovery. 7,000 interviews that did not yield conviction. Evidence that time and storage removed from reach. 60 years of anniversaries. Families who remember Christine and Marianne as they were, not only as a case name. The official findings, stated plainly, are these. Christine Chirac and Marianne Schmidt, both 15, were murdered at Wanda Beach near Cronulla on 11 January 1965. Their bodies were found on 12 January in sand dunes. They had been sexually assaulted and stabbed. Police conducted an extensive investigation interviewing thousands of persons. Multiple suspects were considered. Critical forensic samples listed in historical records, including a semen stain on Marianne Schmidt's costume, could not be located in later reviews. No one has been convicted. The case remains open. Theories continue. Christopher Wilder as offshore serial offender present at Cronulla. Local perpetrator familiar with dunes. Historical suspects including migrants and unnamed beach witnesses. Each theory offers a shape to the silence. None has produced a courtroom verdict. Cronulla tonight holds its coastal darkness. Sand settles in dunes that remember a different January. The file holds its questions. If 7,000 voices can be heard by investigators and still not name the person who walked the girls into the hills, what does it mean to trust that the truth of a summer afternoon must somewhere still be known? On the 1st of September, 1934, a culvert on the Howlong Road west of Albury held a discovery that would occupy Australian public life for a decade. Inside was the body of a young woman, badly burned, wrapped in a sack and a blanket. She wore distinctive silk pajamas with an oriental pattern, yellow in color, and because no one could immediately say who she was, the press gave her a name that outlived many identities of the era. She became the Pyjama Girl. Her case sat in police files, in morgue photographs, and in public imagination through years of depression and war, until dental records and a confession finally attached a legal name to the body. Whether that attachment settled every question history asks is a different matter, and it is one the official record and later historians do not fully agree upon. Albury in the 1930s straddled a border. New South Wales and Victoria met there in geography and in policing. A body found on one side of the line could be moved from another, and the offender who placed this body in the culvert and poured petrol over it and set fire to it understood, at minimum, that discovery would complicate investigation. The burns were severe. Identification by face was impossible in the ordinary way. The pajamas became the signature the public remembered, a detail vivid enough to stand in for a name. Police circulated descriptions. Tips arrived. Leads opened and closed. For 10 years she remained unknown in the official sense, a murdered woman without kin who could claim her. Forensic science in 1934 was not what it would become. Fingerprinting was established. Dental comparison was possible but depended on accurate records and experienced practitioners. The body was examined. Post-mortem findings indicated violence beyond burning. She had been shot. She had head injuries consistent with beating. The manner of death was homicide in the medical assessment, though the identity of the victim and the identity of the killer remained open. Public fascination grew. The Pyjama Girl became a fixture of Australian true crime before the genre had that name, a mystery that newspapers returned to, that newsreels documented, that citizens argued about in tram stops and pubs. Rewards were offered for identification. Inquiries crossed state lines. The body was stored and re-examined as techniques slowly improved. Morgue viewing drew crowds who hoped to recognize a face the fire had taken. None did. The anonymity itself became a kind of celebrity, a woman defined by sleepwear because her name was withheld by death and by the limits of the age's science. In the background of the decade, a couple lived a life that would later be said to intersect with the body. Antonio Agostini, known as Tony, was an Italian-born man working in Melbourne in the Italian community press and in hospitality. Linda Agostini, born Linda Platt in England, was his wife. They moved through Carlton and through social circles where they were regarded, by many accounts, as a presentable pair. Tony would later describe their marriage as troubled, marked by Linda's drinking and by separations that shamed him within community expectations. Linda was reported missing in late 1934. Tony told police she had left him. He was questioned in connection with the Pyjama Girl discovery but was not charged at that time. He moved west to Perth and later to Sydney. He worked as a waiter at Romano's restaurant. In 1940 he was interned as an enemy alien during the war years, held at camps including Loveday, and released in 1944. The identification of the Pyjama Girl occurred in that post-war year. Dental records were re-examined. Police said they matched the body to Linda Agostini, whose records had previously been considered and ruled out in part because of errors attributed to a dentist without forensic experience. On the 4th of March, 1944, Police Commissioner William Mackay, who knew Agostini from Romano's, interviewed him. Agostini confessed. He stated that during a quarrel in bed in Melbourne, Linda was fatally shot with a pistol he said she had held. Fearful of investigation, he transported her body by car across the border to the culvert near Albury, attempted to destroy evidence by fire, and returned to ordinary life. He was arrested, extradited to Victoria, and charged with murder. The trial in June 1944 ended with a verdict that reflected the law and the social attitudes of its time rather than a simple acceptance of Agostini's account. The jury acquitted him of murder but found him guilty of manslaughter. Justice Charles Lowe sentenced him to 6 years imprisonment with hard labor. The judge told Agostini that the jury had rejected his claim that the death was accidental and had also rejected any intention to kill, landing instead on a finding that prolonged provocation and loss of control explained the violence. Agostini served roughly 3 years and was deported to Italy, where he died in 1969. This is the official resolution in law. Antonio Agostini was convicted of manslaughter in the death of Linda Agostini, identified as the Pyjama Girl. It is important to state that official resolution clearly and then to state what historians and later commentators have questioned, because the Pyjama Girl case is one where conviction and certainty are not the same word. Richard Evans, in his book The Pyjama Girl Mystery published in 1924, argued that police under pressure to solve a decade-old sensation may have shaped evidence and encouraged a confession that served institutional needs. He suggested that dental records used to confirm identity may have been unreliable or improperly handled, and that Mackay's relationship with Agostini created conditions unlike a neutral interrogation. These are theories advanced by historical research. They are not findings that overturn the 1944 verdict in any legal sense. The conviction stands. The doubt lives in scholarship and in public debate about whether Linda Agostini was truly the woman in the culvert and whether Agostini's confession described the full truth of how she died. Other theories propose deliberate murder rather than manslaughter arising from quarrel, third-party involvement, or a different victim entirely. The head injuries on the body have been cited by skeptics as difficult to reconcile with Agostini's account of a shooting followed by dropping the body downstairs. Supporters of the official narrative point to the confession, the conviction, and the dental match as sufficient closure for a case that had consumed police resources since 1934. Both positions coexist in the historical record. Sleep narration owes accuracy to both. A man was convicted, questions were not extinguished. The social context matters for understanding why the case ended as it did. 1944 Australia still carried the death penalty for murder. Manslaughter with a term of years was a merciful outcome relative to that risk. Provocation law of the era absorbed narratives of marital discord and female conduct in ways modern courts reject. Linda Agostini's character was discussed in court and press in terms that reflected period prejudice. Tony Agostini's community standing and McKay's patronage of Romanos sit in the background of any account that asks whether justice and convenience were distinguishable in the final act. These are interpretive frames. They do not erase the conviction. They explain why the Pyjama Girl remains taught as both solved and contested. For forensic history, the case marks an early public demonstration of dental identification in Australian crime solving, and simultaneously a lesson in how identification science depends on the integrity of records and practitioners. The Pyjama Girl was displayed for public viewing at one stage in the hope that someone would recognize her, a practice unthinkable now but indicative of desperation to name the dead. When a name finally came, it came through paperwork and confession rather than through a relative's recognition at a morgue window. That pathway is official history. Whether it was the correct pathway is the argument historians continue. Linda Agostini's life before death, as described in court and biography, was one of migration and work, of hairdressing and social evenings, of a marriage that Tony portrayed as strained by alcohol and absence. She had family in England who would later learn of her fate through the Pyjama Girl identification rather than through ordinary notification. The human cost beneath the sensation was a woman missing and a family uninformed for years. Antonio Agostini's internment during the war years separated him from the case's active phase at a time when public attention might otherwise have fixed on him more permanently. His return to Sydney and to Romanos placed him again in McKay's orbit, a coincidence that skeptics treat as less than innocent and that the official account treats as the setting in which confession finally emerged. Newsreel footage from the 1930s shows the public appetite for resolution, crowds and headlines treating the Pyjama Girl as national property. When McKay announced identification and arrest in 1944, newspapers declared the mystery solved. Historians who returned to the file 60 years later did not always agree. That disagreement is not vandalism against the record. It is the ordinary work of history asking whether closure was earned or assigned. A listener need not choose between conviction and doubt to feel the weight of both sitting in the same file for 80 years. Agostini went to his grave in Italy having served his sentence. Linda, if she was the Pyjama Girl, went to hers unnamed for a decade. The pajamas in the photograph outlasted them both in public memory. Albury and Melbourne tonight are separated by the same border Agostini crossed with a body in his car in 1934. The culvert on the How Long Road is a coordinate in maps and memory. Linda Agostini, if she was the Pyjama Girl, was 28 years old and far from her English birthplace. If she was not, then another woman burned in yellow pajamas remains unnamed in the doubt historian's voice. The law named her Linda. Doubt has not fully released that name. For listeners resting in the quiet of a late hour, the case may settle as a study in identification without peace. A body in a culvert. 10 years of anonymity. A commissioner who knew the confessor. A jury that chose manslaughter over murder or acquittal. A sentence served and a man deported. Books that ask whether the wrong woman was buried in the story and whether the right killer was ever sought. A nation that wanted the mystery closed and received a closing that satisfied courts more completely than it satisfied every later reader of the file. The official findings, stated plainly, are these. An unidentified woman's body was found near Albury on 1 September 1934, later known as the Pyjama Girl. In 1944 dental records were matched to Linda Agostini, missing since 1934. Her husband Antonio Agostini confessed to killing her during a domestic incident and disposing of her body at the culvert. He was convicted of manslaughter and imprisoned. He was deported after release. The Pyjama Girl is officially identified as Linda Agostini in police and court history. Theories continue. Historians question the dental identification and the circumstances of the confession. Some argue Agostini murdered deliberately and confession minimized culpability. Others propose the body was not Linda Agostini at all. These theories do not vacate the conviction, but they preserve the case in the category of historical true crime where law's answer and history's question diverge. The border road holds its night quiet. The pajamas survive in photographs rather than on a living woman. The file holds both a verdict and a doubt that 6 years in prison did not erase. If a nation can accept a confession as closure after 10 years of not knowing, and if historians can still ask whether the closed case was the true one, what does it mean to call a mystery solved when certainty remains optional for those who read the record later?